Hey everyone, thanks for joining me for another explainer. Today we're diving into a really incredible legal puzzle. We're looking at the case of DVB Behuising versus the Northwest provincial government. You might also know it as case CCT 22/99. This one is absolutely fascinating because it shows us exactly what happens when the very messy, incredibly urgent reality of dismantling historic injustice collides right into the strict, careful rules of constitutional law.
Justice Ngobo actually set the stage for us perfectly. He wrote, "This matter concerns the constitutionality of the repeal of an egregious apartheid law." So what we're really looking at here is how a modern democracy goes about carefully dismantling the deeply racist legal architecture of its past. I mean, it sounds simple, right? Just tear it down. But as we're going to see today, when you tear down an entire legal system, you have to be incredibly careful that you don't accidentally crush the very people standing underneath it.
Okay, let's just do a quick run-through of our roadmap today. We're covering 6 parts. First, the ghost of apartheid, then the sledgehammer approach, followed by the constitutional test. After that, we'll look at the court's scalpel, some differing judicial views, and wrap it all up with why this matters.
Right, starting off with Section 1, the ghost of apartheid, historical context. To really grasp this dispute, we have to start by understanding the deeply unjust historical context that created this whole legal mess in the first place.
So, let's trace this back. The story actually starts in 1913 with the Natives Land Act. That's the law that drastically restricted African land ownership to just 13% of the country. Then, fast forward to 1962, and the government introduces Proclamation R293. This was a cornerstone of apartheid spatial planning. It established these strictly segregated, highly controlled townships for the African majority, dictating exactly where people could live and heavily regulating practically every aspect of their daily lives. And here's the kicker. This law was still sitting right there on the books when South Africa transitioned to democracy in 1994.
Now, you might be wondering how property worked in these areas. Because black South Africans were legally barred from full land ownership there, Proclamation R293 offered something called a deed of grant. And honestly, this was an incredibly limited, deeply precarious form of land tenure. You didn't truly own the land, the government essentially held it in trust. Your deed could just be revoked at any time if a township manager decided you were not a fit and proper person, or, say, you missed a single payment. On top of that, these deeds weren't even registered in the normal National Deeds Registry. They were kept in special ethnically divided registries run by Bantu Affairs commissioners.
Which brings us to Section 2, the sledgehammer approach, repealing the law. Let's jump ahead to the post-1994 democratic era. The new Northwest provincial government looks at this demeaning racist Proclamation R293 and they want to do the right thing. They want it gone. So they pass Act 7 of 1998, but they don't just tweak it. They take a legislative sledgehammer to it and repeal Proclamation R293 entirely. Boom! Just wiped off the books. But, and this is a massive but, there was a huge unintended consequence. A private business called DVB Behuising, who had been developing and selling homes in these townships, ends up suing the government. Why? Because by totally erasing the law, the province accidentally destroyed the only legal mechanism that existed for registering those old deeds of grant. So suddenly, buyers couldn't register their property. And if you can't register your property, well, the bank definitely isn't giving you a home loan. The province, completely well-intentioned, accidentally froze the property market and blocked ordinary citizens from securing housing finance.
So this sets up a massive constitutional showdown. Yes, the law was undeniably racist and totally unconstitutional in its nature. But did the provincial government actually have the legal authority to repeal all of it? This is the core tension we're looking at today. Can a well-intentioned provincial government actually overstep its constitutional bounds while trying to do the right thing?
Let's move into Section 3, the constitutional test, jurisdictional limits. The case goes all the way to the Constitutional Court, and Justice Ngobo gets tasked with figuring out exactly which pieces of this apartheid law the province actually had the power to scrap.
To figure this out, Justice Ngobo laid out a very precise 3-stage inquiry under the interim constitution. Step 1. Was the administration of the law assignable by the president to the provinces? Step 2. Does the law deal with matters listed in Schedule 6? Those are the functional areas of provincial competence, things like local government and town planning. If the answer is yes, great. But there's a bit of a trapdoor in Step 3. Even if it is a provincial matter, does it deal with something that requires uniform norms and standards across the entire country? Because if it requires national uniformity, the province absolutely cannot touch it.
And that brings us to Section 4, the court's scalpel, separating powers.
Because the province came in swinging a sledgehammer, the Constitutional Court had to step in with a legal scalpel. They had to carefully separate out the provincial powers from the national ones. Justice Ngobo and the majority literally looked at the proclamation chapter by chapter. They decided that chapters 1, 2, and 3, which were all about establishing townships, controlling local populations, and zoning, those were fundamentally about local government and town planning. So those belonged to the province, meaning the province's repeal of those chapters was perfectly valid. But Chapter 9 was different. Chapter 9 dealt with the registration of deeds, and the court pointed out that registering land titles is absolutely something that requires uniform national standards. It has to be consistent everywhere. Therefore, Chapter 9 is a national competence, and the province had zero right to repeal it. By striking down the repeal of that specific chapter, the court essentially turned the National Deeds Registry back on.
Now, you might be thinking, okay, but what about the people who already held those precarious deeds of grant? Did they just lose everything? Not at all. Justice Ngobo highlighted a fundamental rule of law here, saying, the repeal of a law does not take away rights acquired under the repealed law. This scalpel approach was absolutely crucial. It meant that while those oppressive, racist local government structures were finally destroyed, the existing property rights of the residents were completely protected. And actually, thanks to some other national legislation, those old, weak deeds of grant could now legally be upgraded to full, secure ownership. So the province gets to clear out the toxic local laws, and the citizens get to keep and even upgrade their property rights.
Let's look at Section 5, Differing Judicial Views, Debating the Repeal. Because what makes this case even more fascinating is that the top legal minds on the Constitutional Court didn't actually all agree on the best way to handle this.
It's really interesting to see this split here. On one side, we had a dissenting view from Justice Madala. He argued that the province did have total authority to erase the whole thing, deeds registration included, because in his view, the entire proclamation was fundamentally just an evil system of local land use control, and local land use is a provincial matter. But then, on the other side, Justices Goldstone, O'Regan, and Sachs wrote a concurring judgment taking the exact opposite view of the sledgehammer approach. They argued the province couldn't even repeal the land tenure parts in Chapters 2 and 3. Why? Because under Section 25 of the Constitution, the national government is explicitly tasked with fixing legally insecure land tenure that was caused by past discrimination. They felt land reform was just way too critical to be left to a messy patchwork of different provincial repeals.
All right, this brings us to our final segment, Section 6, Why This Matters, the broader picture. Why should we care about this somewhat technical jurisdictional dispute over a law that doesn't even exist anymore?
The takeaways here are actually pretty profound. First off, dismantling systemic injustice is incredibly complex. You can't just wave a magic wand or, swing a sledgehammer and fix everything overnight. Second, good intentions do not override constitutional boundaries. The rule of law applies to everyone, even a government that is actively trying to erase apartheid. Third, this strict balance of power between national and provincial governments, it actually protects people. Because the court enforced those strict boundaries, ordinary homeowners didn't lose their ability to secure bank loans. And finally, legal security is the absolute foundation of economic freedom. Without secure, registered property rights, economic empowerment simply stalls.
Which leaves us with this final thought. We've just seen how the sledgehammer of reform, if it isn't guided by constitutional rules, can accidentally crush the rights of the most vulnerable. So, as we look at democracies all over the world dealing with their own historical legacies, I want to leave you with this. How do we balance the urgent burning need for social justice with the slow, careful, and honestly sometimes frustrating boundaries of constitutional law? Definitely something to think about. Thank you so much for joining me for this explainer today, and I absolutely cannot wait to dive into our next topic with you.